'98. This is not the type of application you are required to give. It is in a prescribed format. ನೀವು ಇಷ್ಟ ಬಂದಂಗೆ ಈ ತರ ಒಂದು ಅರ್ಜಿ ಕೊಟ್ಬಿಟ್ರೆ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ಕಾಗತ್ತಾ? There is a prescribed format for that. They ask for all the details. ಆಗೋದಿಲ್ಲ. Annexure? This is not the type of application. It's a prescribed format. ಅಲ್ಲಿ ಒಂದು ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಂತಾರೆ. And it will be placed before the committee for regularization. ಈ ತರ ಆದ್ರೆ ಆಗೋದಿಲ್ಲ. Is seeking grant of land or regularization? Regularization ಆದ್ರೆ ಆಗಲ್ಲ. Learned AGA takes notice for all the respondents. Next para. Learned counsel for the petitioners submits that the first respondent herein gave a representation on 15/11/1998 to the third respondent Tahsildar, Tumkur subdivision. Seeking regularization of unauthorized occupation of 1 acre and 20 quintas of land in survey number 31 of Amlapura village. Kasba Hubli, Tumkur Taluk. Stop. Thereafter, the first petitioner has given one more representation dated 27/2/2018 at annexure E to the deputy commissioner, Tumkur district, reiterating the same grievance, with a request to ensure that the application of the petitioner is placed before the committee for regularization of unauthorized occupation. So, however, it is contended that the respondents have not taken any action, and therefore this writ petition seeking a writ of mandamus to the respondents to consider the two representations given by the petitioner. We'll stop. Next para. Learned AGA submits that the applications are not in the prescribed format. Stop. Next para. Having heard the learned counsel for the petitioners and the learned AGA, this court is of the considered opinion that at any rate, the respondent Tahsildar and the deputy commissioner are duty bound to consider the representation and to pass necessary orders or to place the requisition of the petitioner before the committee, if the petitioners were eligible for regularization of unauthorized occupation. Stop. In that view of the matter, the petition stands disposed of with the direction to the third respondent, Tahsildar, Tumpur subdivision, to consider the two representations dated so and so, and if the petitioners are eligible for consideration of their application for regularization of unauthorized occupation, the application may be placed before the committee for regularization of unauthorized occupation as expeditiously as possible and at any rate within a period of 3 months from the date of receipt of a copy of this order. Stop. If the petitioners are not eligible for such consideration, then appropriate endorsement shall be issued to the petitioners while assigning reasons. Full stop. Ordered accordingly.
Compared with the order passed by the assistant commissioner, the petitioner was granted that as per annexure B, in year 1978, Form 1, and that is very printed page number 4. What is the copy of grant certificate? For in year 1970 and bodies or annexure, recorded in petitioner. Number 2. Personal showing the last. But the procedure, you can talk from persons who are not in income. But he initiated proceedings that for annexure B passes order. That's a big grant. Annexure given. Annexure B, the petitioner files field before the assistant commissioner who held an inquiry as per annexure G. Annexure A is the order passed by the assistant commissioner. He direct Karnataka ತಾಲೂಕು ಬಾಗೂರು ಹೋಗಿ ನೆವಲಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 382ರಲ್ಲಿ 3 ಎಕರೆ 1 ಗುಂಟೆ ಜಮೀನು ಮಂಜೂರಾತಿಯನ್ನು ರದ್ದುಪಡಿಸಿರುವುದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪ್ರಸ್ತುತ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋಂಕು ರದ್ದುಪಡಿಸಿ ಮೇಲ್ಮನವಿಯನ್ನು ಭಾಗಶಃ ಅಂಗೀಕರಿಸಿದೆ. ಚನ್ನಪಟ್ಟಣ ತಾಲೂಕು ತಹಶೀಲ್ದಾರ್ ಅವರು ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಬಗ್ಗೆ ಖುದ್ದು ಪರಿಶೀಲಿಸಿ ಮರು ವಿಚಾರಣೆ ಮಾಡಿ ತೀರ್ಮಾನುಸಾರ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳಲು ಆದೇಶಿಸಿದೆ. The direction it took the assistant commissioner to make inquiry pass appropriate order. But instead of representation given by the petitioner to the Tahsildar to consider the order of assistant commissioner, so far he has not taken any steps. He has not complied with the order of assistant commissioner. Picture is by representation to the Tahsildar, including copy of the order of assistant commissioner. Which are gave the assignment from the Tahsildar. petitioner has been cultivating the land. Question is here 1978.
What were you doing for all these years? 2000. Huh?
I get representation.
Even representation.
And the next one, there was other alternative except authority.
23 years, sir. 23 years. What?
She followed, but he gave representation.
Even represent. What do you mean by representation?
At the time, the assistant commissioner after holding an inquiry, that he has visited this spot also. For that, the petitioner has been cultivating the land.
No, if the order of the Tahsildar has been set aside by the operative portion, then you are back in possession of the property.
Again cultivating, but the Tahsildar has not considered the order of the assistant commissioner.
But that order of cancellation of the grant has been set aside. Then what more do you want?
The latest entries are not recorded.
So therefore, what should be your prayer? Huh? There is no need, sir. That order of cancellation has been set aside. ಹೌದು.
ತಾಲೂಕು ಬಾಗಲಕೋಟೆ ಹೋಗಿ ನವಿಲೆ ಗ್ರಾಮದ ಸಭೆ ನಂಬರ್ 282ರಲ್ಲಿ 3 ಎಕರೆ 1 ಗುಂಟೆ ಜಮೀನು ಮಂಜೂರಾತಿಯನ್ನು ರದ್ದುಪಡಿಸಿರುವುದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪ್ರಸ್ತುತ ಆದೇಶ ಅನ್ನು ರದ್ದುಪಡಿಸಿ ಮೇಲ್ಮನವಿಯನ್ನು ಭಾಗಶಃ ಅಂಗೀಕರಿಸಿದೆ. ಗಂಗಾಪಟ್ಟಣ ತಾಲೂಕು ತಹಸೀಲ್ದಾರ್ ಅವರು ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಬಗ್ಗೆ ಖುದ್ದು ಪರಿಶೀಲಿಸಿ ಮರು ವಿಚಾರಣೆ ಮಾಡಿ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳಲು ಆದೇಶಿಸಿದೆ. In present in the operative portion, later portion of the order, the representation was made by the petitioner as per annexure here. It was in copy of the order of assistant commissioner. So far, the Tahsildar has not taken steps.
See, technically, that order of cancellation has been set aside.
After the assistant commissioner said, later, operative portion of the order. Now, the Tahsildar is not obliging.
So therefore, your prayer should have been direct them to continue the entry in the land records in terms of the grant. Huh? That order of cancellation has been set aside. Therefore, if there was something to be done by the Tahsildar, you should have done it. So therefore, when the order of cancellation has been set aside, she is entitled to have her name continued in the land record. ಇರ್ಬೋದು. After the assistant commissioner passed the impugned order, if the Tahsildar was aggrieved, you should have continued the proceedings. ಏನು ಆಗಿಲ್ಲ ಅಲ್ವಾ? Learned AGA takes notice for all the respondents. It is the contention of the petitioner that which is the date of order of the grant.
Date of grant is on 3/8/1978.
Where do you get that?
B is the cancellation. 3/8/1978. She was granted grant. In extent of 3/1. Time of the order.
In terms of grant order dated,
If it, Tahsildar signed, below its signature, there is a date here, so the date 3/8.
(19/7, 1978). Comma, 1 acre and 20 quintas of land in survey number of land in survey number 282 of Navile village, Paguru Hobli, Chandrayapatna Taluk, was granted in favor of the petitioner along with many other persons, and thereafter a Sagoli chit was also issued in favor of the petitioner on 3rd of August 1978. 1978. Stop. The name of the petitioner was entered in the land records. Stop. However, at the instance of some third parties, the Tahsildar passed an order on 6/8/1986 in proceedings bearing number LCR bracket B 118 of 1979-80, cancelling the grant made in favor of the petitioner on the ground that the petitioner was holding excess land. Stop. Aggrieved by the orders passed by the Tahsildar, the petitioner approached the Assistant Commissioner, Hassan subdivision, by preferring an appeal, and the Assistant Commissioner passed an order on 18/2/2000 upholding the contention of the petitioner. And while setting aside the orders passed by the Tahsildar on 6/8/1986, however, the Assistant Commissioner directed the Tahsildar to reconsider the case of the petitioner on the basis of the complaint said to have been raised by some third parties. So, learned counsel for the petitioner submits that in spite of the directions issued by the Assistant Commissioner on 18/2/2000, no further action has been taken by the Tahsildar. Stop. The petitioner is therefore seeking a direction in the nature of writ of mandamus to restore the revenue entry in the name of the petitioner in respect of 3 acres and 1 gunta. 3 acres, 1 gunta. Na. In survey number 282 of so and so village, in terms of the grant. Stop. Next paragraph. For contra, learned AGA would submit that although by order dated 18/2/2000, the Assistant Commissioner set aside the orders passed by the Tahsildar, nevertheless, the Assistant Commissioner issued certain directions to the Tahsildar to reconsider the case of the petitioner before proceeding to cancel the grant made in favor of the petitioner. Stop. Therefore, it is submitted that the petitioner cannot seek a direction at the hands of this court to restore the revenue entries. Stop. Next paragraph. Having heard the learned counsel for the petitioner, the learned AGA, and on perusing the petition papers, this court finds that when once the order of cancellation passed by the Tahsildar was set aside by the Assistant Commissioner, legitimately the petitioner was entitled to have her name continued in the land records in terms of the grant. Full stop. Failure on the part of the Tahsildar to hold a fresh inquiry on the basis of complaints received, would not enable the revenue authorities to discontinue the name of the petitioner from the revenue entries. Stop. In that view of the matter, this court is of the considered opinion that the prayer made by the petitioner seeking directions to the respondent authorities to continue her name in the land records pursuant to the grant made in her favor, comma, has to be acceded to. Full stop. Next para. Consequently, while allowing the writ petition, the first respondent, Tahsildar, Chandrayapatna Taluk, is hereby directed to continue the to re-enter the name of the petitioner in the land records insofar as 3 acres and 1 gunta of land in survey number 282 of Navile village is concerned, in terms of the grant order and Sagvali chit issued in favor of the petitioner. Full stop. The name of the petitioner shall be restored in the land records as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order, ordered accordingly.
Yes, the inspection and will allow. Without our knowledge, they project review section allow. We find a interface was allowed. They will do the matter, review by the others. Section has been allowed by this one. Now they have to argue the review.
You are sought for quashing annexure A. This writ petition was allowed.
The other side will not file an application for review. The remand order and what is set aside. Where we have without our knowledge. So we filed an interview. Interview was allowed. And the man was remanded because review he was not having the review. So they have to argue the matter.
Where is that order? Annexure J. Papamma. That was
summer 2019. That was the order.
WP number 14292 of 2009. That was the writ petition filed. The writ petition number 14292 of 2009.
Okay, number 132 of 2021. I is on 2021 and stated.
Where that order passed in the review petition? Oh, Lordship Justice Ravi Maliman. Ravi Maliman. Then why you have you?
Then only then final interview also, they did not disclose. They made a review petition without notice. Then they are not the review petition alone. Then we came to know we final interview. Interview was alone.
All that, but why have you filed a fresh writ petition? The direction was that the review petition in RP number 350 of 2017 has to be reheard.
Regarding mutation. Because during the pendency at the review petition, is pending before this court. Review petition had to be heard by that. Meantime, they wanted to change the mutation. So I was considering a fresh petition. You are actually post that review petition before this court. That's why this article was directly available when it had come up. Post that the review petition has to be heard. According to the petition has been allowed the country granted back the land because of the review petition. Nothing is being proceeded.
Madam, this impugned order has been passed on 25th of May 2022, which has not got anything to do with the earlier writ petition.
Yes. Their petition was allowed by this court. That's why when you want to hear the review petition, then what has to be heard? It's not coming, they will go in the order to go to year 2022. Direction was on that particular day. Year 24/1/2022 for the appropriate date. Still no response.
So since it is a review petition, I can't issue such a direction.
Yes, I got that interview. Then it has to be heard. That has to be heard when after because of this petition.
I'll only issue notice on this matter. Learned AGA takes notice for response number 1 to 3. Issue notice to response number 4 and 5. Learned counsel for the petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. Yes.
But
that has got nothing to do with this matter, madam. This is a fresh order passed in the year 2022. We will see. You move the Honorable Chief Justice. So therefore, an order has to be passed in the review petition. You have to get the matter listed.
Yeah.
I am not in a position. No, please. No, madam, please understand. I can't pass any such direction because it's a review petition.
Yes.
It's a review petition. Normally, the matter comes before the learned judge who has passed the order. Now that the learned judge is not here, appropriate orders have to be passed by the Honorable Chief Justice to place the matter. So therefore, you get an order, let the matter be listed before me, then I'll pass orders. Yes. Not before me. Yes. Illa, you please ensure that the matter. No, you please file a memo in the registry. Let it be placed before the Honorable Chief Justice. Yes.
Yes, rejected by the end of the land grant rules, 1959, it cannot be. Approved by the state and people have actually 48 elected demon. The KT had set aside the order and considered my application in accordance to the. Thereafter, he has not considered my application. I have filed a writ of mandate seeking to direction the value. Now, after and he has given 6 months time. In spite of that, I have not done. I have filed a contempt petition. And I have filed a contempt petition. Now, again, the deputy commissioner has rejected on the ground that under the land and put it on. Next, L to page 48. The thing and everybody, K is for 4 months. There are about 244 adjustment that is being done. Right now, in spite of that, land is available. For a limited purpose, land can go to instead of grown area.
You had applied for grant of Hakkudari land. ಏನಂದ್ರೆ
122 acres.
$102 A
122
of
the Karnataka land revenue rule. 1966. Around 6 months.
one not
102 A.
yes.
Planting of trees by a private person on a government land. The deputy commissioner may subject to the following conditions: grant permission to any person to plant and grow trees on the land connecting the state government. It's the only provision providing him. Now he says that under the land grant rules, I am not claiming to the highway, no person of particular right, only for a limited purpose of growing the of planting and growing the. So he is specifically directed that that is not the ground, which is 102 acres, that is within a block one, and to consider the same in accordance with them. If they have not done this, you have to contempt the petition to apply. When contempt is required, now again the deputy commissioner will take on the same. Okay, that land is not ours, in spite of availability of 244 acres that it is. That's
Is it a matter of right that you can then then you had earlier also filed a writ petition. You had earlier also filed a writ petition before this court. I think I've heard this matter. Any directions that I had passed? Annexure? Page number?
29. Not permitting the picture, making investigation, and we should consider that in the light of the observation made by Ch-8, actually number 5.
Amele, it was not considered. So you filed a contempt petition.
Now again, as per
And get clear. On 21, 7/7/21. Natural, by you.
ಏನಾಯ್ತು ಆದ್ಮೇಲೆ K18 you challenge the order of the deputy commissioner before the K18. So therefore our question is, as a matter of right, can you say no they have to give me the then
Provision authorized the authority, permitting him to grant it. That has been considered as a claim.
yes sir, but there is no compulsion on the part of the deputy commissioner that he has to grant it.
He said that.
You can make a representation. See, this is not a matter of right. You are only trying to express a cause in the interest of public. I am interested in planting some trees. If you give me this place, I will plant trees and buto. But as a matter of right, can you say no, I will file an application, you have to give it to me? Then, so therefore, sir, what is it that you want now? ಮಾಡಿದಾರಲ್ಲ, ಎರಡನೇ ಸರಿ ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರಲ್ಲ, ಏನ್ ತಪ್ಪಿದೆ ಅದರಲ್ಲಿ? So therefore our question is, what is that right that is vested in you? ಬರೋದಿಲ್ಲ. These are all indirect tactics to see that you get possession of the land, you plant trees, and thereafter you claim, raise a claim. No, ನಾನು ಇಷ್ಟೆಲ್ಲ ಮಾಡಿದೀನಿ, ಕಷ್ಟಪಟ್ಟಿದ್ದೀನಿ, ನನಗೆ ಕೊಟ್ಬಿಡಿ ಎಂದು. ಆಗೋದಿಲ್ಲ. If you want some land to be granted, you file an application in accordance with law. All this exercise will not take you anywhere. ಬರ್ಕೊಳ್ಳಿ. No sir, no sir. It's not a matter of right that you should say no, it has to be granted to me. So if you want grant of land, you make an application in accordance with law. This is not possible. No. That is regularization of unauthorized. Adalla. There is a provision under the land grant rules for grant of land. If you are eligible. If you are not eligible, you will not get it. So if you want a grant of land, you make appropriate application in accordance with law. Let them consider. But idu invoking rule 102A as if it's a matter of right. ಆಗದು. ಎಷ್ಟು ಸರಿ ಸರ್ ಡೈರೆಕ್ಷನ್ ಕೊಡೋದು? Correct. Where is the order of the deputy commissioner? Just given complete reasons. There is no place available there. Please read ink page number 50. Internal page number 3 of the order. Vodi. Sufficient reason. ಹೌದ್ರಿ, ಬೇರೆಯವರೆಲ್ಲ ಫಾರ್ಮ್ ನಂಬರ್ 53, 57 ಹಾಕಿದಾರಲ್ಲ. Annexure? Survey number 118. They have given full details of survey number 118. ಅದೇ ಹೇಳಿದಾರಲ್ಲ, ಅವರು ಹೇಳಿದ್ದಾರೆ. ಬಟ್ there are others who have filed the application in form number 53. No. They have given complete details. Then at HCGP takes notice for all the respondents. The petitioner, who is aged about 76 years, has been knocking at the doors of this court for many years now. So, it is his contention that he is capable of planting trees and growing them for the benefit of the general public and the government. Stop. The petitioner has made several representations invoking the provisions contained in Rule 102 capital A of the Karnataka Land Revenue Rules, 1966. Which enables the deputy commissioner to grant permission to any person to plant and grow trees on lands vested in the state government. However, subject to the conditions enumerated therein. Full stop. On the previous occasion, the petitioner had approached this court in WP number 4959 of 2020, seeking such direction to the deputy commissioner to grant permission to plant trees in survey number 118 of Tambihalli village, Puttur Hombli, Kolar district. Stop. The deputy commissioner had in fact rejected the application, and the said order was confirmed by the Karnataka Appellate Tribunal in appeal number 527 of 2018. Stop. Nevertheless, a submission was made by the learned government advocate, additional government advocate, that the petitioner's representation will be considered in terms of the directions issued by the Karnataka Appellate Tribunal within a period of 6 months from the date of receipt of a communication of the order of this court. Stop. Accordingly, the petition was disposed of, permitting the petitioner to make a representation enclosing a certified copy of the orders passed by this court within 15 days. And the deputy commissioner was also directed to consider the same within a period of 6 weeks, as was directed by the Karnataka Appellate Tribunal. So, when the deputy commissioner did not pass any orders, the petitioner filed a contempt petition in CCC number 212 of 2021, bracketed civil. Stop. During the course of the contempt proceedings, the deputy commissioner passed an order on 7th of July 2021, and the same was placed before the Honorable Division Bench. Stop. The Division Bench held that if the petitioner is aggrieved by the said order dated 7th of July 2021, he may challenge the same in accordance with law. Stop. Accordingly, the petitioner challenged the said order dated 7th of July 2021 before the Karnataka Appellate Tribunal in appeal number 347 of 2021. Stop. The tribunal passed the impugned order dated 29th of August 2022. Dismissing the appeal. Full stop. Next para. Learned counsel for the petitioner submits that the tribunal has not considered the grievance of the petitioner having regard to the express provisions contained in Rule 102, capital A of the rules. So, next para. For contra, learned HCGP would submit that in paragraph number 17 of the impugned order, the tribunal has considered the fact that the deputy commissioner has assigned cogent reasons for rejection of the application made by the petitioner. Stop. Next para. Having heard the learned counsel for the petitioner, the learned HCGP, and on perusing the petition papers, this court finds that Rule 102, capital A cannot be read as a provision that confers a right in favor of the petitioner. Stop. The provision was inserted subsequently on 6/9/1974 only to make provision that if any person is interested in planting saplings and growing trees in lands vested in the state government, it would be in the interest of the general public and the state. Stop. It is not as a matter of right that the petitioner can claim that if he makes an application, it has to be considered and the permission has to be granted by the deputy commissioner. Stop. In the considered opinion of this court, such a provision is a discretionary provision, and the deputy commissioner is entitled to use his discretion before granting such permission. Stop. Nevertheless, on going through the impugned orders passed by the deputy commissioner and the tribunal, it is clear that para number 17 ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, (16 and 17 ಅಂತ ಟ್ರೈಬ್ಯುನಲ್ paragraph 16, 17 ಎರಡು ಅಂತ. It is clear that survey number 118, where the petitioner is seeking permission for planting the saplings, has a total extent of 244 acres and 30 guntas. Full stop. An extent of 166 acres and 25 guntas have already been disposed of. And in respect of the remaining 78 acres and 5 guntas, it appears that various persons have filed applications in form number 53 and 57 seeking regularization of unauthorized occupation. Stop. In that view of the matter, the deputy commissioner has assigned reasons for not acceding to the request made by the petitioner. Stop. It is also evident from paragraph number 17 of the impugned orders passed by the tribunal that Tambihalli village has 263 cattle heads, and in terms of the provisions of the Karnataka Land Revenue Act and the rules, the cattle heads in the village require 78 acres of land for grazing purpose. So, it is therefore clear that no land is available for being permitted to the use of the petitioner. Although such usage and planting of these saplings would not be for the benefit of the petitioner, but for the benefit of the general public and the state in general. Stop. Next para. Having regard to the reasons assigned by the deputy commissioner while rejecting the requisition made by the petitioner, comma, this court does not find any infirmity in the orders passed by the deputy commissioner and the orders passed by the Karnataka appellate tribunal. Stop. Next para. Consequently, the writ petition stands dismissed.
Point raised.
This also mother. The petitions for approaching is okay also. Again, the hospital was rejected. The opportunity on the duty of the hospital. Again, assistant commissioner, before the assistant commissioner, are in the 2020. Again, the responding was 5 also. Get address, filed 8 existing annexes, actions. Only challenge, only the contesting response. After paying the REs, the plus due to what say reason with this assistant commissioner was issued notice to hospital as annexure D.
What is your basis of your claim?
My claim is in the
What is the basis? What is the basis of your claim? Where is that?
1978.
19?
1978 we have.
Where is that? Where is that?
Not this, because we are challenging only. The change of numbers.
You are challenging only?
Yeah, DC orders, because. Total. Considering the delay application and so on. The directly the commission was passed an order. Same day, 5 months, our day has set aside the Indian AC assistant commissioner order and remains 3 year demand. You can see the annexure accused last annexure to orders. Yes, filed on 14/8/2020. Assistant commissioner order passed on January 2020. After delay of 7 months, the number 5 was challenged at the same assistant commissioner order before the DC. It's filed on 14/8/2020. Page number 87. Yes, challenge at the same before the DC on 14/8/2020. Same day, without
14?
giving any opportunity, without any notice. Same day has been considered and the same day has been followed and said remained at the assistant commissioner. Today, not at all give any notice and not at all considered by any section by a Limitation Act.
Where do you get the dates?
They produce the table. Table of the filing date is in page number 80 page, filing date. Bottom of some columns.
Page number?
83 connection to is last. Table copy of connection.
14/9/2022.
State Commissioner order passed on January 2022. As the next
January?
12th January 2022. The next G is page number 45.
So it's not on the same day.
This order has been set aside by the DC. Annexure A, can you see the annexure A? Assistant Commissioner passed on order on 12th January 2022 in favor of
12th January?
12th January 2022 as
Aito.
annexure A. The same was the respondent was challenged before the DC.
On 14/9/2022.
Yes. 14/8/2022. Same day the DC as concerned by the revision petition has been followed and remained back to the same without notice to the petitioners.
Which is the order passed by the annexure A? That is 28th of October 2022.
Yes. It's filed dated shows, but is hearing date.
How are you saying it's on passed on the same day?
Hearing date is coming on 28th October. What was passed on 28th October, but hearing on the reserved order. That was hearing on. That was hearing on 14/9/2026. All of this also set aside. and-
That we do not know. We'll have to get the complete information. We can't go by that one. But anyway, you please make your submissions on the merits of the matter if you want interim orders.
No dispute between us. My savior was not at all disputes with us. His only dispute is, this is the 100 acres of global land is granted, all these, we are both the.
Learned HCDP takes notice for response number 1 to 3. Issue notice to response number 4 to 6. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on the learned HCDP.
Okay, sir. Without notice and written, definitely, section 5 applications.
Yes, let us see. Yes.
Five acres, nothing in which, as per annex A and B, the entire extent was converted, in the year 1958 and 2004. Subsequently, out of these two sites, the portion of properties and portion of property and there's also civil code 15. Subsequently, what has happened is,
Official memorandum dated 13/8/2016, annexure D. What is that?
That is the, what happened, property is converted in 88 itself, again by showing the new number, 37/38 and sub number. Second conversion order has been obtained. And subsequently, we complained with the revenue authority, the body has been cancelled, RTC also was cancelled. The property is converted in 88 in 2004. However, what happened, the deputy commissioner after coming to gaining the knowledge that the misrepresentation they have taken. By annexing, we got the order, let us say. That was happening before this order. This order was put, also the order must be, he cannot take on the order.
Yes.
That's the reason.
Yes.
So, I know on the basis of this claim, we all are taking the motion for non-existent property, they are trying to take control of main property. In fact, the itself is converted as
No, if you say that this court has already considered the case and it has held that the deputy commissioner could not have passed such an order.
The deputy commissioner cannot recall his own order.
Correct.
Now they are approved by a repetition by the honorable court for seeking this.
Learned HCGP takes notice for response number 1 and 2. Issue notice to response number 3 to 5. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on the learned HCGP.
Applications to the identical petitions by February 2020. The remaining petitions are written up together and an identical issue order has been passed. This copy of the petitions were raised in this petition.
What is the matter about?
This is the cancellation order by the deputy commissioner of unauthorized cancelling unauthorized application, regularization of unauthorized application. That copy package, copy package, not being regularized, not of very. If it is 400, 220. That stands for when the PDA confirm the application, all the copy package.
You see that? Please give a copy of that order. Same order. Same order as in WP number 1457 of 2023, dated 15/2/2023.
Getting to the office and answers. Not have a petition copy.
You had not filed any caveat. ಮಾಡಿದ at the request of the learned counsel. You received a copy now today at the request of the learned counsel appearing for the caveat respondent. Caveat respondent released this matter on 8th of January. Yes. Where is form number 53? Huh? Page number? Huh. Dodolapura. Dodolapura. ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಗ್ರಾಂಟ್ ಮಾಡಿದಾರಾ? Learned AGA takes notice for all the respondents. Learned counsel for the petitioner is direct to serve a copy of the writ petition along with annexures in the learned AGA. Please stop next para. It is the grievance of the petitioner that although she filed an application in form number 53 on 28/4/1999 seeking regularization of unauthorized occupation of 4 acres of land in survey number 23 of Mallegowdanahalli, Saslu Hobli, Dodballapur Taluk, the same has not been considered till date. Stop. The petitioner has also given a representation on 29/12/2022 at Annexure H. Stop. The learned AGA is directed to secure instructions from the third respondent Tahsildar, Dodballapur Taluk, as to why the application of the petitioner has not been placed before the committee for regularization of unauthorized occupation. ಆಗಿದೆಯಾ ಮತ್ತೆ ಎಲ್ಲಿದೆ? ಹಾ
ಮಾಡುತ್ತಿದ್ದಾರೆ. ಈ ಗ್ರಾಮದಲ್ಲಿ 161 ಪ್ರಾಥಮಿಕ 68 ಸರ್ಕಾರಿ ಜಮೀನು ಲಭ್ಯವಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಇವರಿಗೆ ಜಮೀನನ್ನು ಸರ್ಕಾರಗೊಳಿಸುವುದು ತೀರ್ಮಾನಿಸಲಾಗಿದೆ.
ಸಾಗುವಳಿ ಚೀಟಿ ತೆಗೆದಾಕ್ಬಿಡಿ, ಎಲ್ಲ ತೆಗೆದಾಕ್ಬಿಡಿ. ಇದು ನೋಟಿಸು ಕಾಪಿ ಅದಿರ್ಲಿ. It is the grievance of the petitioner that although the committee for regularization of unauthorized occupation passed an order on 28/2/2012 taking a decision to regularize the unauthorized occupation of 3 acres and 35 guntas of land in survey number 23 of so and so village in favor of the petitioner, nevertheless, till date, grant certificate has not been issued to the petitioner. Stop. Learned AGA is directed to secure instructions from the third respondent Tahsildar as to why the grant certificate has not been issued in favor of the petitioner, in spite of the decision of the committee on 28/2/2012. Full stop. Release this matter on 9th of January.
Second time, period number 12. Interpret.
A week's time is granted at the request of learned counsel for petitioner for compliance of office objection.
Ready?
Same order. 12, same order.
First time, period number 30. Where from DG?
Finally, a week's time is granted at the request of learned counsel for petitioner for compliance of office objection.
Period number 14. Karnataka. Proposal.
Same order, 14, 15.
Conference for fourth time, period number 16. Unita Hexing.
Order sheet, put it. Same order. Finally, a week's time is granted.
Conference of office objection for sixth time. Suresh Babu.
Same order.
18.
Same.
Conference for sixth time. Number 19, Manjunatha Naik.
Put the order sheet. Same order.
Suresh Kumar Acharya.
Same order. 21, same order.
22. Seventh time, non-compliance.
Same order.
Alright, period number 23. Here, mediator.
Matter is called out. There is no representation for the petitioner. Stop. Over. Finally, a week's time is granted for payment of process fee for issuance of notice to the proposed respondents on IA number 123 of 2021. Pleading applicant who has filed? PD Surana. Objection is that copy is not served on you. ಅದಲ್ಲ ಫಾಸ್ಟ್ ಟೈಟಲ್ ಸರಿ ಇಲ್ಲ ಅಂತ. Office has raised an objection that the cost title furnished in IA number 1 of 2023 by the impleading applicant is not correct. Stop. There is no representation for the impleading applicant. Full stop. Nevertheless, a week's time is granted for complaints of office objections. Finally, a week's time is granted for furnishing the process fee for service of notice on IAS number 123 of 2023. IA number 1 of 2023 impleading application. ನೀವು ಹಾಕಿರೋದಾ? ಏನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್? Copy not served on the advocate for respondents. Huh? You served. Learned counsel for the petitioner as well as the other respondent. You all petitioners, you know? ಅಲ್ರಿ ಕಾಪಿ ಬಂದಿದ್ದೇನ್ರಿ ನಿಮ್ಗೆ? ಅದ್ರಲ್ಲಿ ಹಾಕಿದಿರ. You are not a respondent there. In that writ petition you are not a respondent in that other petition. ಅದನ್ನೇ ಕೇಳ್ತಾರ ಮತ್ತೆ. You have not received a copy. ಕೊಡ್ರಿ ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡ್ರಿ. Learned counsel for the petitioner as well as the other respondent submit that they have received a copy of IA number 1 of 2023. Stop. Of the objection is complied. Yes. Next para. A week's time is granted at the request of the learned counsel for petitioner in the connected writ petition for furnishing. Learned counsel appearing for the petitioner in the connected writ petition submits that the needful has been done. Full stop. Office to verify and issue notice. Yes. Interim order granted earlier stands extended till next date of hearing. Or objections ಅಂತ ಹೇಳ್ತಾರೆ. Learned counsel for the petitioner submits that the amended cost title will be furnished in the office during the course of the day. Yes. The learned counsel is also permitted to carry out the amendment in the cost title during the course of the day. Okay. Interim order granted earlier stands extended till the next date. Learned counsel for the petitioner has served a copy of the writ petition on the learned HCGP.
When application for then first officer is respondent number 3. Just later that for this observation, later not be named. Last day of application, the document is taking also apply.
Order on IA number 1 of 2022. This application is filed by the petitioner seeking to implead the range forest officer, Bhadravati forest range. So learned counsel submits that there is a reference to the said officer in the impugned order, and therefore it has become necessary to implead the officer. Full stop. Accepting next para. The submission of the learned counsel for the petitioner, the application is allowed while permitting the range forest officer Bhadravati forest range to be impleaded as a party respondent to these proceedings. The learned counsel shall carry out the amendment in the cost title and furnish amended cost title within a period of 1 week from today. Finally, a week's time is granted for furnishing the proper process fee and to take steps for service of notice on respondent number 5 and 6. Process fee and to furnish copies of the writ petition. And for complaints of the office objections raised on IA number 1 of 2023. Yes. Yes. Huh? For petitioner. ಈ ಕಡೆ ಬಂದ್ಬಿಡಿ. Memo for disposal of writ petition. 79 AB, 79 AB. Please come to the synopsis. 2004, you purchased the property. Seven sale deeds, sir. 7 sale deeds. Action certificate. Assistant Commissioner passed the order on 2/11/2007. ಆಮೇಲೆ ಏನಾಯ್ತು? 2005. So the order has been passed against a dead person. You are not aware of the order.
similar circumstances.
ಆಯ್ತು ಬರ್ಕೊಳ್ಳಿ. Learned, ಆಯ್ತು ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆಯಲ್ಲ? ಹಾ ಆಗಿದೆ. This is a matter arising out of the provisions contained in section 79A and B of the Karnataka Land Reforms Act. Stop. It is an admitted fact that Sri Muhammad Mustafa purchased where is the impugned order? ಎಷ್ಟು ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಎಷ್ಟು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದು? About 5 acres of land in survey number 146 bar 1, 146 bar 2, 150 bar 2 and 150 bar 2 of Kannamangala village, Idarahallu Hubli, Bangalore East Taluk, under 7 separate seal deeds, in the year 2004. Stop. However, proceedings were initiated invoking the provisions contained in section 79A and B of the Act by the Assistant Commissioner, Bangalore North Taluk, and orders were passed on. The impugned order was passed on 2/11/2007, declaring that the purchaser has violated the provisions contained in section 79A and B of the Act. Stop. However, learned counsel for the petitioner submits that Sri Muhammad Mustafa, who had purchased the property in the year 2005, died on 14/11/2005. As would be seen from the death certificate at Annexure J. So, the learned counsel would therefore submit that the impugned order has been passed against a dead person and no information was available to the legal representatives of Sri Muhammad Mustafa. Stop. Next para. ಕೊಡಿ ಅದು. ಬೇಡ ನನ್ನೇ ಕೊಟ್ಟಿರ್ತಲ್ಲ ಅದನ್ನು ಕೊಡಿ. Nevertheless, this court has taken note of the amendment brought to the provisions in terms of the Karnataka land reforms, bracketly second amendment, close Act, 2020, while omitting the provisions contained in sections 79A, B, and C. Stop. It was also noticed that as per section 12 of the amending act, all cases finally disposed of before the promulgation of the Karnataka land reforms, bracketly amendment, close ordinance, 2020, bracketly Karnataka ordinance 13 of 2020, close, shall remain unaffected by the ordinance. Stop. Section 12 bracket 2, however, provides that all cases pending before any court, tribunal, or other authority competent under the provisions of the Principal Act on the date of the promulgation of the Karnataka land reforms, bracketly amendment, close ordinance, 2020, pertaining to sections 79A, B, and C shall stand abated. Please stop. Next para. The contention of the petitioners, who are the legal representatives of Shri Mohammad Mustafa, that the impugned order has been passed against a dead person, has to be accepted. So, however, the benefit flowing out of the amending act may be available to the petitioners only if the lands in question have not been thereafter forfeited and disposed of in accordance with law. Stop. Under such circumstances, benefit have been given to such persons who have approached this court. Stop. The Assistant Commissioner is therefore required to ascertain whether the declared excess lands or forfeited lands still remain with the state government or has been granted to third parties. Stop. If the lands have been granted to third party, then subsection 1 of section 12 of the amending act will apply to say that the proceedings have reached finality. Stop. Or otherwise, subsection 2 of section 12 of the amending act will apply, and all further proceedings shall be declared as abated by the Assistant Commissioner. Stop. For the reasons stated above, this court proceeds to pass the following order. The impugned order dated so and so, passed by the Assistant Commissioner, is hereby quashed and set aside. Stop. ಮಿಕ್ಕಿದ್ದು 2 and 3 same. The petitioner is required to appear before the Assistant Commissioner on 22nd of January. Yes. Huh? Learned Counsel Shri M.S. Prakash ವಕಾಲತ್ ಹಾಕಿದೀರಾ? Submits that he has already filed wakalat on behalf of respondent number 3. Stop. The learned counsel also undertakes to file wakalat for respondent number 4. Stop. Office is directed to verify and show the name of the learned counsel in the cause list. Next para. How about respondent number 6? Karnataka State Pollution Control Board. ಯಾರ ಪೇರ್ ಆಗ್ತಾರೆ? Mahesh Chaudhary. Learned counsel Shri Mahesh Chaudhary is requested to take notice for respondent number 6. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on learned counsel for respondent number 6. Yes.
Lord, serial number 32, my lord.
Yes.
Lord, I take to appear on behalf of respondent number 8, my lord. File my wakalat in the counter, my lord. My lord, and respondent number, I'll file my wakalat in the counter, my lord.
Mr. CM Raghunath had filed a caveat petition.
Please, my lord, now the wakalat has been given to me, my lord, for respondent number 8 and respondent number 9 died, my lord.
9. You also want to appear on behalf of respondent number 9.
Please, please.
8 and 9.
8 and 9.
Seema Sri Ramachandra.
Sri
Ramachandra.
That is respondent number 8.
Hanumakka.
Please.
The caveat petition was filed on behalf of all these private respondents or only 2 of them? Only 8.
Only 8. Only 8.
Non-compliance of office objections.
Well, I have no knowledge of something. So I have said it was major. Major by agent, other majors. So that business are they come up with the AC and try to seek insertion of the names of the daughters in the RDC. No, at that stage it is not responded to out of the group they are in position in the past 70 years. Out of the group it comes and finds an implementing application after an application expired. And now in the implementing application, not in prayers, it must be heard, doesn't matter. But there is no specific prayer sought by anybody, it is not that the name of the respondent number is inserted, it is not in the RDC. My name is friend directed, the assistant taken out the notes of the RDC. And the respondent name will be inserted there. I think they interfere in my position, is I gather as a judgment to be passed by conference in court. I now before the deputy commissioner. What the deputy commissioner does is if there is a civil court pending, so my appeal is also dismissed. I have challenged the legality, integrity, and correctness with the order of assistant commissioner. Deputy commissioner goes to the and says, I dismiss this after revision petition because of the reason that there is a suit pending. So I also had the suit case. If the suit was pending, then if the petition before the assistant commissioner has been dismissed in the first instance. Directions have been issued to come up after the necessary suit is decreed.
Where is the order of the assistant commissioner? Annexure Q.
Lord, could it be taken up next week, my lord? I file my statement also, my lord.
You were also a respondent before the assistant commissioner.
Please.
I impleaded.
Proceedings before the assistant commissioner, what mistake they have created? My name is Arvind. Anand Anta Bargata. Some name called Anand is written. I am placed with X party. Those steps are taken.
What is your the basis of your claim? What is the basis?
My vendor, other was granted at least under official policy, right? Non-punishment. Thereafter, the property came to the son. son and the daughters joined together and executed the sale deed to me.
When?
2003.
2003. So the basis is sale deed.
Sale.
2003.
Invitations are taken.
So ಅವಾಗಿಂದ ನಿಮ್ಮ ಹೆಸರಿದೆ.
Whether as a patient-
ಅದಲ್ಲ. ಹಾ. ಹಾ.
Invitation like
So these people challenge the entry of your name.
the words of my vendor's father.
Uh-huh.
They came up before the assistant commissioner. Yes, respondent number 8 did not file any petition.
Who is the respondent number 8 and 9?
He gave some sale deed notice in survey number 26. Another survey number 66.
So ಅದಕ್ಕೂ ನಿಮ್ಗೆ ಸಂಬಂಧ ಇಲ್ಲ.
But ಅವ್ರಿಗೆ RTC ನನ್ನ ಹೆಸರು ಅವ್ರಿಗೆ ಆರ್ಡರ್ ಮಾಡಿದ ಅಸಿಸ್ಟೆಂಟ್
8 and 9.
8 ಹೆಸರಲ್ಲಿ he included himself in that proceeding. ಅವ್ರ ಹೆಸರು ಹಾಕಿ
ಹೆಂಗ್ರಿ?
Lord, I don't have copy of the petition, my lord. Your lordship may have it next week, my lord. I'll also file my statement, my lord.
Learned counsel Shri Nandish Patil
Please.
appearing through video conference submits that he has filed wakalat on behalf of respondent number 8 and undertakes to file wakalat on behalf of respondent number 9.
9, please. In fact, my lord, my instructions are number 9 has died, my lord. The mother has died.
Respondent number 8 full stop. The learned counsel further submits that he has instructions to state that respondent number 9 Srimati Hanumakka is no more.
Please.
Is no more. Stop. Learned counsel seeks for a short accommodation to make his submissions. Full stop. Release this matter on 9th of January. Please come on 9th of January. We'll dispose of the matter.
Please.
Yes.
Obliged.
ಮಿಕ್ಕಿದವ್ರಿಗೆಲ್ಲ ಸರ್ವಿಸ್ ಆಗ್ಬೇಕಲ್ಲ. ಆಯ್ತು, let us see. ಆಯ್ತು, ನಾಟ್ ನೆಸೆಸರಿ. ಅದನ್ನ ನೋಡೋಣ. Yes. Release this matter on 9th of January for final disposal. 10th of January for final disposal. All right. ಇವಾಗ ಏನ್ರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಬ್ಜೆಕ್ಷನ್ಸ್ 2017 ಮ್ಯಾಟರ್ ಅವ್ರು ಹಾಕಿದಾರಂತಲ್ಲ, ಇನ್ನೇನ್ ಸಾಕಲ್ಲ, ಇನ್ನೇನ್ ಬಿಡಿ. ಅದು ತೆಗ್ದ್ಬಿಡಿ. ಅದು IA number 1 of 2023 has been filed by respondent number 10 seeking early hearing of the matter. Full stop. Learned counsel submits that he has filed statement of objections on behalf of the said respondent. Full stop. However, learned counsel Shri B.N. Suresh Babu submits that he is yet to file statement of objections on behalf of response number 5 to 9 who have a different claim. Stop. Acceding to such submission, a week's time is granted to response number 5 to 9 to file statement of objections. Full stop. A copy of the same shall be served on the learned counsel for petitioner as well as the learned counsel for the other respondents. Full stop. New copy is put. List this matter. Next para. List this matter for final hearing on 18th. 18th of January.
Which matter because we are we have also on a earlier occasion we have disposed of another petition. The lawyer had asked whether it can be alignment to be changed, not have been done by later. We are Supreme Court order. In fact, even your lordships were also passed an order in this matter also. And there were other connected matters which had come up. Their issue was not the preliminary and final notification were caused. So the Lord, they have also said complete the entire acquisition in accordance with law, pay the compensation in accordance with law, outer limit of 6 months, because PRR, the Honorable Supreme Court seat and the also Supreme Court has said that you have to complete the PRR. In fact, there were some reports even in the newspaper that this PRR is required. So one matter you also disposed of the matter, saying that copy, I have it here, your lordships on 18/11/2023. He lost it, my lord, dispose of the matter. So, my lord, here the only difference ultimately, my lord, is that preliminary notification was issued and final notification has not been issued. So, my lord, ultimately, my lord, we'll have to complete that acquisition, pay them the compensation. You have also seen the order dated.
How is it LB matter? How is this classified as LB matter?
Karnataka time.
Allah, see, if your case is that in this petition, you are issued a preliminary notification.
Oh, they are not challenged acquisition.
What is the prayer in the
prayer in the repetition that they had sought for the plan approval by from the Kanakpura thing, which was
no, how can they ask for plan approval when you have proceeded for acquisition?
Yes, ma'am. Their prayer is to issue a writ of so and so to quash the input endorsement bearing number so and so issued by court respondent dated 16/6/20. Issue a writ of so and so to consider the representation. So, their case, even in the earlier case which you also disposed of on.
No. That was a case where they had succeeded in challenging the acquisition notification, and therefore they had a right. So first they had to get a declaration.
Yes.
By filing a writ petition that the acquisition proceedings have lapsed or something like that.
Yes.
Only then they will get a right to go before the planning authority to seek approval of the plan. Otherwise, they can't. It cannot be done. ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೋ ಇದರಲ್ಲಿ ಪೆಟಿಷನರ್ಗೆ? ನರೇಂದ್ರ ಅವರೇನಾ? ನರೇಂದ್ರ
ಅವರೇ your lordships were to actually dispose of the matter, saying that this also will dispose of on that day. However, they insisted and got it.
Matter is called out. There is no representation for the petitioner. Stop. Release this matter on 9th of January. ಹೌದು 11th of January. Yeah. For change of khata. ಅದೇ ಭೌತಿ ಖಾತೆ. ಎಲ್ಲಿದೆ ಅದು ಆರ್ಡರ್?
Not
2007.
They are not considered. Despite that also approach. Content proceedings, they consider then. Section C not in the order of the Tahsildar. If they are not served notice also. Section C not can be seen. Tahsildar, the order of December 4. Has taken proceedings on board. But they are not-
Annexure C.
Section C not page 39 not the type copy. They have not issued any notice to me. He contended that there was no documents are fabricated, and they are not considered. Then he concluded. This party. This party. Very clear document. This party. If you based on the document, ತಿಳುವಳಿಕೆ ಕೊಡಲು ಗಾಂಧಿ ಗ್ರಾಮದ ಮಾಧ್ಯಮ ವರದಿ ಮಾಡುತ್ತಾರೆ ಅಧಿಕಾರ ಬಿಟ್ಟು ಸಚಿವ ಗಾಂಧಿ ವಾಪವಾಗಿದ್ದಂತೆ ಜಾರಿ ಮಾಡಿ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿದೆ ಎಂದು ಸಾದಾಗ ಜಮೀನಿನ ಮೇಲೆ ಚಿತ್ತಕರಿಸಿದ ವರದಿ ಮಾಡಿ ಮಾಜಿ ಮಂತ್ರಿ ನಂತರ ದಿನಾಂಕ ಡ್ಯಾಶ್ 2007 ಮತ್ತೊಂದು ತಿಳುವಳಿಕೆ ಕೊಡಲು ಅಧಿಕಾರಿಗಳಿಂದ ಮೂಲಕ ಕಳಿಸಲಾಯಿತು ಸದರಿ ವಿಳಾಸದಲ್ಲಿ ಮಾಸಗಳಲ್ಲಿ ಅದರಿಂದ ವಾಪಸ್ ಮಾಡುತ್ತಿದೆ ವಿಚಾರವನ್ನು ಅಂಚೆ ಇಲಾಖೆಯನ್ನು ವಾಪಸ್ no notice or something. And he contends that I am not in possession.
Here is the question of you are not being in possession. Say your brother was granted that land.
Brother was he died.
You are only asking for mutation entry
Mutation.
subsequent to his death.
Subsequently.
Where is the question of conducting this inquiry? Sir, but if his brother's name is entered in the land records, consequent to the grant, he is entitled to ask for change of kata.
Consequently.
How can you now go back to find out as to whether there is a grant in favor of his brother? How did you maintain the revenue records in his name then?
Consequently, grant not revenue is not affected by brother.
Not affected.
He made representations. They are not considered. Subsequently, he died. I approach this on.
ಆಯ್ತು, ಇವಾಗ ಏನ್ ಮಾಡ್ತಾರೆ ಇದಾದ್ಮೇಲೆ?
There was issue of
1989.
89 earlier, but that was recent issue on 7/2020. Last. The deputy commissioner, the same land was proposed for grant to Murugarajendra Mata. Deputy commissioner conducted an inquiry and told that land was granted to me. Kindly come to the.
Gayatri, what did you do about this order passed by the Tahsildar?
I challenge before the deputy state commissioner. Section B. Assistant commissioner said the same thing. He confirmed the order of the assistant. Annexure B. And kindly see page 30. They accept the order of the assistant.
All right. Learned AG takes notice for all the respondents. Learned counsel for.
Notice what are saying.
It's come up for hearing on IA. IA 1 of 2023 for production of certified copy. If you are challenging, you will have to produce certified copies. IA 1 of 2023 filed by the petitioners is disposed of while directing the petitioners to furnish the certified copies of annexures A, B, and C, which have been impugned in the writ petition, within a period of 2 weeks from today. Huh?
3 weeks.
3 weeks from today. Interim order granted earlier stands extended till the next date of hearing. Yeah, 1 of 2023 for direction. Huh? Huh.
When the application was pending before the Akram committee, the order was passed. It is on 18th 2020.
Ah.
It is on village stay ಅಂತ ಬರ್ತಾರೆ ಅಲ್ಲಿ this order was passed. That's why I'm challenging it. While doing so, I removed all my pens and other material and concept and everything. That is record and filing. I have filed the application to release that material.
Release the seized material.
Material. And agricultural fence and singular fencing and the concept and.
Yes. Please give back the material. We will consider the matter on merits, but the material which belongs to them has to be given back to them. Order on IA number 1 of 2023. This application has been filed by the petitioner seeking a direction to respondents number 2 to 4 to release the seized material in terms of the Mazar dated 33/2023. Stop. Learned Counsel submits that while the communication was made by the Deputy Commissioner, Dakshin Kannada District to the Tahsildar, Sulia Taluk on 18/3/2023 to evict the petitioner from the land in question, a Mazar was drawn on 30/3/2023 and the material belonging to the petitioner have been seized in terms of the Mazar. Stop. Learned Counsel submits that pending consideration of this writ petition, a direction may be issued to the Tahsildar to release the material, because they belong to the petitioner and it is evident from the Mazar drawn by the Tahsildar. Full stop. Next para. The submission of the Learned Counsel for petitioner is accepted. Full stop. The respondent Tahsildar, Sulia Taluk, is directed to return the material seized in terms of the Mazar dated 33/2023 to the petitioner, since seizure of the material has nothing to do with the merits of the matter. Full stop. While the matter will be decided on merits, the Tahsildar is required to return the materials which belong to the petitioner. Full stop. Next para. Accordingly, the application is disposed of with such direction to the Tahsildar, Sulia Taluk to return the material seized under Mazar dated 33/2023 to the petitioner within a period of 1 week. Huh? Mazar ಅವ್ರ ಹತ್ರನೇ ಇದೆಯಲ್ರಿ. They have seized it with the Mazar, so they have to return it. That's all. Within a period of 1 week from the date of receipt of a copy of this order.
Last year, 18 to 20.
ಅದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆಯಾ? List this matter along with WP number 5999 of 2022. In terms of the directions issued by this court on 18/12/2023. Full stop. List these matters on 9th of January. ಏನ ಪಾಠಾಡ a last sentence ಚದುಬಿಡಿ. Office to take note of the orders passed by the coordinate bench on 18/12/2023 in WP number 5999 of 2022. Yes. Any early? Yes. Yes. Is this matter of the service of notice on respondent number 5? ಏನ್ರಿ ಇದು? What is this? ಹಾ ಹಾ
Just one project, popcorn project. 300 acres have been given to them. They're investing nearly exactly 22,000 crores. The question before your honor is around others around 40-50 acres. They consider only with 10 acres insofar as this project.
See, I've also put it to them that I have passed orders and similar circumstances. You should understand. Now, if you are insisting that it's not difficult for me to pass orders today itself. Huh? All right. When do you want the matter? Huh? 9th of January, Tuesday. Huh? ಆಯ್ತು 10th ಆಗ್ಬೋದಾ? ಅದೇ see, we'll dispose of the matter on merits. There is no difficulty. At the request of the learned counsel for petitioners, release this matter on 10th of January. Yes. Interim order granted earlier stands extended till the next date of it. That is called out. There is no representation for either of the parties except the learned HCGP. Release this matter on 9th of January.
And let's go. Yes, that. That will not be the store. It must find third point. Taking that they are interested in the land. And the deputy commissioner and contending that I am not the drafted son. Therefore, my order, order was 3 points. I tried a inspection goes on for some person that may be said that I have proved that I am. Therefore, I tried a civil suit. There is a government in offer that. That suit has been declared in the court. Now we got is that I said that is
Second appeal.
Second appeal is pending.
Regular appeal ಏನಾಯ್ತು? Regular appeal was dismissed. You had filed the suit.
And declaration was not made. I filed an appeal. In appeal, the entire suit has been out. Holding that I am profits.
So the RSA is pending now.
Now, before that, we can in that case. This case, this is a case where the Padavich has been.
What remains if you have compromised and you have settled the matter? What remains? That is because of the objections raised by them.
I had challenged that order before the Supreme Court.
ಆಯ್ತು. Now there is a declaration in your favor. ಅಷ್ಟೇ ತಾನೆ. ಅಷ್ಟೇ. All right.
You already filed compromise. Yes.
RSA ಅಲ್ಲಿ ಹಾಕಿದಾರಾ? ಅದು RSA ಕೊಡ್ರಿ. Respondent number 1 ಗೆ 1 acre 28 ಗುಂಟ. So that is you. So therefore, you please tell us the date. At the request of the learned counsels on both the sides. Release this matter on 10th of January. The parties are required to be present in view of the compromise petition filed by them. Has been rejected.
Only on so long, that it is within the limit of 18 kilometers.
When did you file the application?
My application was filed. Was 12/11/98, page 25 is my.
98.
98. But as on the date of the application, because it was beyond the limit of 18. Lord, may look at page 29.
Yes, I have disposed of many matters while considering this situation, and I have held that the boundary of the corporation has to be taken into consideration as it was and on the date of the application.
Subsequently, what they have done is after rejection, because they are supposed to have allotted it to the contract. That cannot be a ground today also to say.
Ah. ಏನ್ ಮಾಡಿದಾರೆ ಅದನ್ನ ನೋಡಿ. ಅದು ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅದು ತರ್ಸಿಟ್ಕೊಳ್ರಿ ಅದು ನಾನು ಆರ್ಡರ್ ಮಾಡ್ಬೋದು. ಹಾ yes. At the request of the learned additional advocate general, release this matter on 11th of January. Yes. Ah. Hmm.
There was one more application that I read. Who would say take instructions and was not my client is Christian, he was not Christian. That means he could not come in contact. It's under time. Take instructions for time and
Request of learned counsel for the petitioner, release this matter on 11th of January. Full stop. In the meanwhile, if any rejoinder is required to be filed to the statement of objections filed at the hands of the contesting respondent, the same may be done while serving a copy of the same on the learned counsel for the respondents. Interim order granted earlier stands extended till the next date. Hmm? Furnishing of process fee, copy covers for notice on respond number 9. Huh? Finally, a week's time is granted. Huh? 2023 matter, sir, ido. Finally, a week's time is granted at the request of learned counsel for petitioners for taking steps for service of notice on respond number 9. Yes. Huh? ಯಾವುದು? Take action against the petitioners for disobeying the order. Stop. In the meanwhile, objections, if any, are also required to be filed in respect of IA number 3 of 2023, filed at the hands of respond number 3 to 8. Yes. ಯಾಕೆ ಇಷ್ಟೊಂದು ಕಡಿಮೆ ಹಾಕಿದ್ದಾರೆ ಮ್ಯಾಟ್ರಿಗಳು? Yes. 79. Hmm.
55 to 73 of
Confirm. When was that order passed by the KAT?
Lord, in this case, what happens in the year 2019, the appeal was dismissed on non-prosecution. Thereafter, due to COVID, the petition couldn't oppose the KAT, despite the original petition before the KAT. In the original petition, the delay has not been confirmed. Solely on the ground of delay, the petition has been rejected. The order of rejection of this petition on 21/8/23. Is a connection C without page number 21, order of rejection of my.
To recall the order dated 16/1/2019.
Yes.
When did you file the review petition?
So the review petition was filed in year 22.
Your delay ಎಷ್ಟಿದೆ ಅದರಲ್ಲಿ?
2019. Was in between those 2 years of COVID allowed first. That was the reason. Has been explained, and basically we got the order of dismissal of the petition on the ground of non-prosecution was not intimated.
Anyway, the same principles would apply. If it has, I don't think it has been disposed of anyway. Land would not have been disposed of. Sorry. Sorry. Where is the earlier order of the tribunal?
Their order of the tribunal is not at. Number 17. Page number 19 is the order. Type copy is page number. For the only business for non-prosecution.
Oh. Narayanachari purchased the property.
The petitioner purchased the property on 30/11/2007. Same day. That is an annexure E.
The said Narayanachari and his family members ಅಂತ ಹಾಕಿದೀರಾ?
Like he earlier purchased and the present petitioner after his purchase the proceedings were initiated.
Huh?
Is the proceeding against the petitioner?
No, please come to your list of dates and synopsis. (30/11/2007), Narayanachari and his family sold the said property.
There is a error here. We got the original grantee was Narayanachari. And Narayanachari's family members sold the property to the present petitioner.
On 30/11/2007. 30/11/2007.
The present petitioner purchased the property from Narayanachari.
You purchased it as an individual.
As an individual on 30/11/2007. Then the proceedings were initiated and order was passed on 19/9/2008. I filed an appeal and appeal was before the non-prosecution 16/1/2009.
Yeah, already.
I filed a petition on 25/9/22.
This is a proceedings. Parkalam. This is a proceedings. Initiated under section 79A and B of the Karnataka Land Reforms Act. Stop. The petitioner herein purchased 3 acres and 5 guntas of land in survey number 74 of Kadatanamalai village, Esargatta Hobli, under registered sale deed dated 30/11/2007. Stop. Proceedings were initiated by the competent authority or assistant commissioner in proceedings bearing number LRF bracket 83, another bracket B and A, close 24/2008/2009 for contravention of the provisions. Stop. An order was passed by the assistant commissioner on 19/9/2008, holding that the sale is in contravention of the provisions contained in section 79 capital A and B of the Act. Stop. The petitioner filed an appeal before the Karnataka Appellate Tribunal in appeal number 958 of 2008. Stop. However, by order dated 16/1/2019, the appeal was dismissed for non-prosecution. Stop. Learned counsel for the petitioner submits that the petitioner was not aware of the fact that the appeal was dismissed for non-prosecution. Full stop. Nevertheless, the petitioner filed a review petition in review miscellaneous number 41 of 2022 before the tribunal, and the tribunal passed the impugned order dated 21/8/2023, declining to accept the reasons furnished for condonation of delay of 1319 days in filing the review petition. Full stop. Next para. This court had several occasions to consider such cases where writ petitions are filed long after the provisions contained in sections 79 capital A, B, and C were omitted from the statute book in terms of what are the amendment in terms of the Karnataka land reforms, bracketally second amendment, close act, 2020. Stop. It is the opinion of this court. It has been the consistent opinion of this court that at any rate, if the assistant commissioner after forfeiting the land has not disposed of the same in accordance with law, then the benefit of the saving clause contained in section 12 of the amending act is required to be given to such petitioners. Full stop. Next para. The assistant commissioner is therefore required to ascertain ಅಲ್ಲಿಂದ ಇಲ್ಲಿ A to A ಅಂತ ಮಾರ್ಕ್ ಮಾಡಿರ್ತೀನಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 5 ಅಲ್ಲಿ ಸೇಮ್ ಅದನ್ನ ಹಾಕೊಂಡು ಪ್ಯಾರಾಗ್ರಾಫ್ 6 ಮತ್ತೆ ಆರ್ಡರ್ ಇಲ್ಲಿ ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ಡೇಟೆಡ್ ರಿವ್ಯೂ ಮಿಸ್ಲಿನಿಯಸ್ ಅದೇ ನಂಬರ್ ಇದೆ ಇದರಲ್ಲಿ ನಂಬರ್ ಚೇಂಜ್ ಆಗುತ್ತೆ ಡೇಟ್ ಚೇಂಜ್ ಆಗುತ್ತೆ ಆರ್ಡರ್ ಆಫ್ ದಿ ಎ ಸಿ ಅದನ್ನು ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ ದಿ ಮ್ಯಾಟರ್ ಇಸ್ ರಿಮಾಂಡೆಡ್ ಬ್ಯಾಕ್ ಟು ದಿ ಸೇಮ್ ಆರ್ಡರ್ as in WP number 1217 of 2020 dated 24th of January 2022. Yes. ಒಂದು 60 ಹಾಕ್ರಿ 60 65 70 ಹಾಕ್ಬೋದು
Court officer? Court officer? Court officer? Court officer? Court officer?
ಹೇಳಿ ಸರ್. ಎಸ್
ಸರ್ ಎಷ್ಟನೇ ಮ್ಯಾಟರ್ವರೆಗೂ ಆಗಿದೆ?
ಆಯ್ತು ಸರ್, ಸಿಟ್ಟಿಂಗ್ ಕಂಪ್ಲೀಟ್ ಆಯ್ತು.
ಹೌದಾ? ಸೀರಿಯಲ್ ನಂಬರ್ 37 ಏನಾಯ್ತು?
ಸೀರಿಯಲ್ ನಂಬರ್ 37 91
91 ಸರ್ ಎಂಟ್ರಿ ಆರ್ಡರ್ ಇತ್ತು ಅದರಲ್ಲಿ.
ಆಗಿದೆ, ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಡೇಟ್ ಕೊಟ್ಟಿದ್ರೆ ಅಷ್ಟೇ ಸರ್, ಅದು ಕನೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಅದು ಬರೋದಿಲ್ಲ ಅದು.
ಸರ್ ಏನಾಗಿದೆ ಸರ್, ಅದು ಕನೆಕ್ಟ್ ಆಗಿದೆಯಾ?
ಹೌದೌದು, ಸೊ ಅದು ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದು ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ಸ್ ತಗೋಬೇಕು ಅದಕ್ಕೆ, ಅದೇನು ಮಾಡಿಲ್ಲ.
ಅದೇ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಮುಂದೆ ಆರ್ಡರ್ಸ್ ತಗೋಬೇಕಲ್ವಾ?
ಹೌದೌದು,
Okay.
ಆರ್ಡರ್ಸ್ ತಗೊಂಡ್ಮೇಲೆ ಆಮೇಲೆ ಅದು ಏನಾಯ್ತು, ಅದು ಬೇರೆ ಏನೋ ಆರ್ಡರ್ ಆಗಿಲ್ಲ.
ಇಂಟರ್ಮೋಟ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗಿದೆ ಅಲ್ಲ ಅಷ್ಟೇ?
ಇಲ್ಲ ಸರ್, ಆಸ್ ಇಟ್ ಇಸ್ ಹಾಗೆ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿದೆ, ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ, ಅದು ಆರ್ಡರ್ ಮೇಲೆ ಇದಾಗುತ್ತೆ ಅಷ್ಟೇ.
ಓಕೆ ಸರ್, ಓಕೆ ಸರ್.